On a freezing Tuesday morning at Sandringham House, King Charles literally pulled an emergency hardware kill switch from inside his private dressing room. The entire palace communications network went completely dark for hours while he rewrote his secret will. This is not a metaphor, a rumor, or tabloid exaggeration. It was a physical, unilateral digital blackout executed by the reigning sovereign. The crisis began in the Sandringham Library when the King's private secretary, Sir Clive Alderton, opened a heavy leather dispatch box under a desk lamp. Resting on top of the routine state papers was a single sheet of heavy vellum stamped with the sovereign's private cipher watermark. It contained 5 lines of text written in an archaic Victorian code used by royal estate lawyers for over a century. To an outsider, it looked like a standard property description for a cottage in Aberdeenshire. In reality, it was a pre-arranged legal trigger, ordering the keeper of the privy purse to immediately freeze the distribution logs of the monarch's personal investment portfolio. Under a legal agreement dating back to 1993, the private wills of deceased British monarchs are automatically sealed from public view for a minimum of 90 years to protect the true extent of crown wealth from Parliament and tax authorities. But the document Charles was modifying that morning was not a standard post-mortem will. It was an active codicil designed to alter the distribution of non-crown assets while he was still alive and reigning. Within minutes of Charles reviewing the text, Sandringham's automated security servers shut down. Terminal screens went blank, displaying a flashing red status icon. Local IT technicians tried to reboot the system, but their administrator codes were rejected. Charles had physically thrown a Cold War-era master override switch from his dressing room, using a backup tool designed for national security emergencies to sever the internet line. He did not want his digital traffic monitored by the Central Palace network in London while the new legal text was drafted. While the network remained dark, his personal physician walked out holding a sealed leather pouch and handed it directly to a motorcycle courier waiting in the courtyard, bound for an undisclosed location by 11:00 a.m. Prince William's chief financial officer at Kensington Palace noticed a complete data freeze from the Sandringham registry on their shared financial tracking system. The digital bridge that allowed both offices to coordinate on estate management had been entirely severed from the northern end. William immediately tried calling his father's personal mobile line, but the device was out of network range. When he called the Sandringham switchboard, a senior operator informed him that the king was resting and had issued strict orders that he was not to be disturbed by anyone, including his heir. That was the moment senior advisors in London began to genuinely panic. Sandringham House and Balmoral Castle are held personally by the monarch, not the Crown Estate Corporation. They are personal property worth hundreds of millions of pounds. A sudden secret shift in their future ownership would trigger an unprecedented legal battle within the family. Sitting at a small writing table by the window in his Sandringham study, Charles reviewed an open leather ledger detailing the yields of the family's land banks. He dipped his fountain pen into black ink and began writing the final adjustments to the inheritance schedule while rain beat against the glass. The financial records involved listed specific offshore holdings that had never been brought into the public domain, corporate bonds and equities purchased during the late 20th century, completely separate from the land-based wealth of the Duchy of Lancaster. For 30 years, these specific funds had been managed outside public view by a small, trusted committee of trustees meeting biannually in Edinburgh. Charles was now redirecting them with a few strokes of his pen. William's legal team in London convened an emergency session in the basement offices of the High Court of Justice to review historical charters. Their panic escalated when a secondary confirmation came through from a banking contact in Zurich. A transfer of ownership form had been submitted digitally to a private Swiss depository just minutes before the Sandringham network went dark. The transfer involved a highly valuable cache of historic gold bullion, held in trust for the descendants of King George V since 1936. The king was using his unique legal status as sovereign to systematically dismantle specific institutional reserves without parliamentary or family approval. Hours after the network lockout occurred, the legal fallout crossed the Atlantic. A duplicate copy of the Norfolk Amendment landed on a sleek granite kitchen island in Montecito, California. An assistant in a gray uniform carefully sliced through the thick security tape with a silver letter opener. The top sheet didn't feature standard royal heraldry. It was a cold corporate asset reallocation order bearing an alphanumeric registry code from the Norfolk County Court. The document directly targeted the financial structure of Prince Harry, completely dismantling the remaining UK financial provisions set aside for his lineage. The baseline facts of Harry's financial arrangements were rooted in a series of trusts established by his great-grandmother in 1994. Those funds were legally structured to distribute millions of pounds in dividends once he reached specific age milestones. The palace had always maintained that these trusts were legally separate from operational crown funds. The document in Montecito proved otherwise. Flipping to page 14% of the amendment, the text explicitly altered the residency requirements for all future trust payouts. Under the new rule, any beneficiary who maintained a primary tax domicile outside the British Isles for more than 5 consecutive years was automatically disqualified from accessing the core principal. The money would instantly revert to the general pool of the Duchy of Lancaster. The 5-year marker was a precise calculated threshold that aligned perfectly with Harry's departure in 2020, a deliberate retroactive financial severance. A secondary clause introduced a strict non-disclosure mechanism. Any legal challenge brought against the amendment by a disqualified beneficiary would automatically trigger a full public disclosure of all private financial audits relating to their post-royal commercial ventures. It was an ironclad gag order written into a financial deed. Furthermore, a line item involving a historic diamond and ruby tiara originally gifted to Princess Diana in 1981 was completely removed from the family inheritance listing. The piece had been designated for Harry's children since the late 90s, but the king quietly reclassified it as an official diplomatic gift rather than personal property. By doing so, he legally transferred the item into the state collection at the Tower of London, ensuring it could never be inherited, exported, or used as collateral abroad. Finally, a small footnote officially transferred the physical copyright of Harry's teenage letters stored in the Sandringham Library directly to the office of the Prince of Wales. Under British law, this gave William absolute legal authority to block any future memoirs or documentaries quoting those early interactions. Harry's legal representatives in London confirmed there was no court of appeal. The king had operated entirely under the Sovereign's Personal Property Act. While the paperwork was being reviewed in California, Prince William boarded a twin-engine helicopter in London. The rotors chopped through heavy rain as the aircraft banked over the waterlogged fields of Norfolk. Mid-flight, regional air traffic control ordered the pilot to abort the planned flight path to London and descend immediately near the northern boundary of the Sandringham estate. Sandringham's legal status is unique. Its geographic jurisdiction was fixed by a historical property agreement in 1902 as private land bought personally by Queen Victoria. Unlike Windsor Castle, the reigning monarch possesses absolute legal authority to bar any individual from entering the grounds, including the direct heir to the throne. William stepped out of the helicopter into driving wind and rain. A protection officer held a black umbrella over his head as he walked rapidly toward the rear entrance, where a senior land steward named David Hill was waiting. The steward, visibly nervous, informed the prince that the king's personal physician had issued a strict medical isolation order for the upper floor. No family members were permitted access without a signed clearance certificate from the medical board. William pushed past the steward into the grand hallway. The central elevator installed during the 2022 renovations was completely deactivated, its digital panel displaying a system error message caused by a breaker switch flipped inside the king's study. William was forced to take the oak service staircase at the back of the building. When he reached the top landing, he found a pair of heavy, iron-reinforced security doors closed across the main corridor, a defensive installation added in 2023. William pressed his thumb against the biometric keypad. A sharp red light flashed twice, followed by a low electronic tone. His biometric entry privileges had been completely erased from the local system registry within the past 2 hours. Through the narrow glass viewing slit in the security doors, William saw Sir Clive Alderton walking down the inner corridor carrying a locked leather dispatch case tagged with a blue customs label, signifying an international diplomatic transit item. William knocked sharply on the glass panel. The private secretary stopped, looked at the prince, and shook his head slowly. He held up a signed executive order from the king commanding all staff to maintain total operational silence until the documents left the estate. His own father had locked him out of his own private estate. William walked down to the ground floor library, opened his laptop, and pulled up the secure registry of the Duchy of Cornwall to dissect the historical charters. At 4 p.m., 3 individuals walked into the ground floor conference room carrying leather-bound notebooks and black fountain pens. Dame Sarah Aspen, a senior high court judge, Sir John Baker, Chancellor of the Diocese of Norwich, and Professor David Starkey, an expert in constitutional history. Under the Wills Act of 1837, a sovereign's private will amendments cannot be witnessed by family members, palace employees, or anyone who stands to benefit from the estate. The law requires that all witnesses must be physically present in the same room at the same time to see the testator sign, and then sign the document themselves in his presence. William entered the room through a side door and laid down a printed copy of the Wills Act regulations, stating firmly that any amendment reallocating historical family heirlooms required a secondary certificate of verification from the Victoria and Albert Museum. The judge looked up and informed the prince that the king had already secured that specific certificate during a private audience in London 3 days prior. The legal paperwork was procedurally airtight. The private secretary placed the master copy of the amendment on a wooden reading desk. Bound with a green silk cord and sealed with the private signet ring of the House of Windsor, the 3-page document lay open. The constitutional professor noticed the small blue ink stamp on the back page reading Registry Office of the Duchy of Cornwall. That stamp indicated that a portion of the assets being redistributed belonged to William's estate rather than the king's personal portfolio. William demanded an immediate halt to the proceedings, but Sir Clive immediately pulled a secondary folder from his briefcase. revealing a signed property exchange agreement from 2023. During a routine administrative cross-lease for land near Highgrove that William had signed years earlier, a hidden subclause gave the reigning monarch the reciprocal right to reallocate an equivalent value of non-land assets during a family restructuring. William's own past signature on routine estate paperwork had left him legally trapped with no ground to stand on. At exactly 4:20 p.m., King Charles walked into the room leaning on a silver-topped walking cane. He did not make eye contact with his son. He walked straight to the reading desk, put on his glasses, sat down, and picked up his fountain pen. Dipping it once into the inkwell, he signed his name at the bottom of the third page. The three witnesses stepped forward in silent succession. Dame Sarah signed first, followed by Sir John, and finally the professor. Each signature was stamped with a physical wax impression from the Sandringham state seal. The entire procedure took less than 3 minutes, conducted in absolute suffocating silence, without a single word spoken between father and son. The moment the final witness finished, the private secretary locked the document back inside the dispatch case. The paper was now a permanent, legally binding reality that could no longer be altered by any family court, parliamentary committee, or future monarchical decree. Charles stood up, adjusted his coat, and walked back toward the elevator doors, leaving the room without making a statement. William remained in the library alone as the black sedan carrying the witnesses pulled away into the Norfolk fog. On the green leather desk mat lay a small sheet of blotting paper bearing the fresh, dark impression of the king's signature. The palace had not used public relations or family meetings to resolve its internal war. It had used the absolute authority of property law to enforce permanent compliance and absolute silence. This high-stakes legal execution fundamentally alters the distribution of power and wealth within the House of Windsor for generations to come. By pulling that emergency hardware switch at Sandringham, King Charles didn't just isolate himself for an afternoon. He quietly cut the financial ties binding his family, putting the future of the monarchy entirely under his terms. Prince William now faces a restructured inheritance bound by rigid legal conditions, while Prince Harry's financial standing in the UK has been systematically severed. The royal family's carefully maintained public image of tradition and unity has been superseded by cold, unyielding legal strategy behind closed doors. Was King Charles right to use emergency sovereign powers to secure the crown's private wealth, or did he cross an unforgivable line by locking out his own sons? Drop your thoughts in the comments below. Share your take on this palace showdown, and make sure to subscribe for the next deep dive into the House of Windsor.